Good morning. This is Ron Mickens. You know the topic. Fraud upon the court. The truth is in the detail. So what? You got to stay with me. Stewart Title Information Service Corporation / Stewart Title Guaranty Company. Purchased injustice. He hired the judges, hired the state attorney to deprive us of our life, liberty, and property. To what? To destroy us with fraudulent misrepresentation, fraudulent orders, and fraudulent judgments. To set us to be killed, set us up to be killed by a sheriff's SWAT team. So this is what the blood money is for, is to gain at the cost of another's life or livelihood. It's money paid to destroy the life of the livelihood of some other person. That some other person, meaning us. So they are purchasing injustice. Jerry Hill, he conspired and agreed from the very beginning to deprive my wife and I of our life, liberty, and property. Make no mistake about it. He knew it like he knows the back of his hand that we were entitled to a judgment against all of the co-conspirators as a matter of law based on their confessions. Okay? Stewart Title Guaranty Company, Stewart Title of Polk, the Damrons, Canady, Rewis, Highsmith, and the Polk County School Board. But he chose to sacrifice us, and over 40 claims he's going to cover up, to destroy, to deprive us of our relief, of our damages, fees, and costs for over 40 claims. That's including against Stewart Title Guaranty Company and their co-conspirators and the Polk County School Board. So you know the Polk County School Board got to be included, got to be part of the conspiracy to deprive me and my wife of our livelihood, of our life, liberty, and property interests. The Polk County School Board, they failed to follow the state and federal Constitution. The Fifth Amendment to the Constitution provides that no, nor shall any person be deprived of life, liberty, and property without due process of law. The 14th Amendment, Section 1, states that nor shall any state deprive any person of life, liberty, or property without due process of law. Fundamental fairness. This requires that notice and the right to a fair and impartial hearing is accorded or afforded prior to the deprivation of life, liberty, and property. Okay? Let's start with the common law. The Supreme Court precedent case in education, Cleveland Board of Education versus Laudermill, guarantees us some notice, some kind of notice and some kind of hearing prior to depriving us of our jobs, our reputation, our good name. Arlington versus Ham with the 11th Circuit precedent case, they provided that due process prevents mistaken, wrongful, or unjustified termination. That due process was before the deprivation. And of course, here in Florida, Florida Statute Chapter 231.36 requires and guarantees us notice, hearing, and just cause before your job or your life, liberty, and property interest can be deprived. Okay? They never establish just cause. So just like Administrative Law Judge Cave said a long time ago, it was impossible for them to terminate my contract without just cause. The school board, they failed to follow the Florida Administrative Codes, the ethnic codes of the education profession, the principles of professional conduct, the Florida Statute Chapter 286, the Florida Sunshine Laws. They failed to follow the school board policies. They failed to follow school board policies 3.005 subsection 2, which was mandatory, imperative, that they follow these progressive due process steps exactly, okay? Anytime you have due process procedures established, they should be followed exactly. Now, I was deprived of due process. I was provided with what I call a 33 months substantially delayed post termination malicious prosecution, vexatious litigation. Okay, it was without probable cause, so they didn't even meet the qualifications to even have a hearing. Okay, it was a malicious prosecution. That is not due process, is what I'm saying to you. The administrative law judge / the school board found that the school board administrators and the superintendents were not credible. They were not believable. They were dishonest. The ALJ, the administrative law judge / school board, found that the administrators' procedural derelictions was what? Manifold and egregious, outstandingly bad. He found that the school board administrators / superintendent conducted an uninterrupted sequence of abuse against me. He found that the school board administrators, Superintendent Glenn Reynolds, Kellen Baldwin, Dennis Dunn, Bill Landry, Superintendent's attorney Don Wilson, terminated me based upon a vague, legal, non-existent factual allegation, and that the school board ratification of the superintendent recommendation was just done without due care. They just did it to get it over with. Okay, that's just negligence on their part. They found that and determined that the Polk County School Board administrative conduct was what? Ultra vires, outside the law, that they lacked authority. They required me to undergo psychological evaluation, to what you call the employment assistant program, without a factual basis and without authority. This is all outside the law and a denial of due process. I was not charged with a particular violation of either Rule 6B-1.001 or Rule 6B-1.006, Florida Administrative Code. It was a malicious prosecution. I hate to say hearing, but it was a litigation, because it was what? Without probable cause. You call it vexatious litigation. It's just an abuse, malicious abuse and misuse of the legal process. Dale McDonough was the Polk County School Board school investigator. The administrative law judge / school board found that his investigation was desultory, disconnected, consisted of a hodgepodge of vague, inconsistent, uninformative, disconnected student and faculty statements. It was not a fair and impartial investigation. Okay. They going to give me a written reprimand without due process, just totally improper, violating the progressive disciplinary steps. The superintendent, I gave the superintendent a total of 30 due process violations. You know what he gave me in return? He gave me a speech, a non sequitur speech, telling me, talking about this, how this won't hurt me. And basically what he said, it won't hurt me if I could show them that I could be a good, I hate to use these terms with you, but a good Stephen Fetcher Negro. If you just do whatever we tell you to do, how we tell you to do, think what we tell you to think, then this will disappear. Okay, so stay with me. Okay, we have to deal with reality. So stay with me. If these events would have not had occurred if the school board policies had been followed, they violated the common law, statutory law, the administrative codes, the code of ethics, school board policy, the whole 9 yards. The administrative law judge and the school board found, in summary, it is concluded that the school board failed to establish by a preponderance of the evidence that Ron Mickens committed misconduct in office, even under the most generous view of the school board's vague legal and non-existent factual allegation. They failed to establish a preponderance of the evidence. Okay, these are their findings. These are their findings. The administrative law judge / Polk County School Board finding. This shows where I was not afforded due process. I was illegally ordered into the EAP program and to undergo psychological testing without authority and without a factual basis. Carolyn Baldwin, the area superintendent, she clearly understood that her actions was what? Ultra vires, outside the law. And it was evidenced by her temporizing effort to say that the word requiring did not mean requiring. It meant what? Recommended. Mr. Reynolds, Superintendent Reynolds, could not state under what specific authority he ordered me to undergo a psychological evaluation. The record is unequivocally clear that there were absolutely no authority. The AJ, the administrative law judge, and the school board found that the superintendent did not handle this matter properly. And they stated that given Ron Mickens' character and his previously spotless record, it is not unreasonable to believe that he would still be serving as an assistant principal, if not a principal for the Polk County School Board. Okay? The school board adopted these findings. This was what? Their confession of guilt. So they adopted these findings. So they are what? They are barred. They are estopped. They are precluded from contradicting these findings. They are barred as a matter of law. These are their findings. These are their conclusions of law. Okay. Now here comes the federal district court. Here comes the fraud upon the court. Judge Merriday and his magistrate judge, Judge Stephen Merriday, and his magistrate judge Wilson. They got to commit fraud upon the court to extricate the Polk County School Board, the Polk County School Board members, the Superintendent Glenn Reynolds, and his administrators from their liabilities and responsibilities for their torts and their crimes against me. Okay, they abused and misused what you call a report and recommendation. This was a tool that they used to deprive me of due process and equal protection of the law. The Polk County School Board and the administrative law judge final order was adopted in its entirety. So this was the confession of their guilt. They had no defense. They were barred. They were estopped. They were precluded from contradicting their own final order. This was as a matter of law. But Judge Wilson and Judge Merriday being the district judge, they had to commit this fraud upon the court to turn what? The winners into the losers, to turn the victims into the tortfeasors / criminals, to turn the innocent into the guilty, the just into the unjust, and the honest into being considered as the dishonest ones. Judge Merriday and Wilson, they fraudulently misrepresented that I, Ron Mickens, was accorded or afforded due process and equal protection of the law, in direct contradiction to the administrative law judge, the Polk County School Board, the EEOC, Department of Labor and Employment Security, the Education Practice Commission, in direct contradiction contradiction to the Constitution, the common law, statutory law, the administrative code, the ethic code, the principles of professional conduct, and school board policies and procedures in direct contradiction. And they fraudulently cited McKinney versus Pate as the authority. McKinney versus Pate, McKinney was given 13 charges in a 3-day hearing before he was disciplined. You see the fraud upon the court? They're just doing this to extricate the wrongdoers from liability and responsibilities for their torts and their crimes. The EEOC found 14 employees outside of my protected class. All of them was afforded or accorded notice, hearing, and just cause. I was not. This is what? Unequal treatment. This is mistreatment. This is disparate treatment. This is what? A denial of due process. I was never given notice nor a hearing. I was terminated based on what? Remember, a vague legal, non-existent factual allegation. Okay. This deprived me of substantive and procedural due process, my freedom of speech. I was stigmatized, retaliated against, I was discriminated against. This was what you call the administrative hearing really turned into being what? Vexatious litigation, because they never established probable cause. It was what you call malicious prosecution. Malicious prosecution, ladies and gentlemen, is not due process of law. Okay, the final order did not establish just cause. So, like administrative law Judge Games said, it's impossible for them to terminate me. Okay, they could only terminate me if they established just cause, and they did not. And they what? They never reinstated me. Okay, Judge Meredith, the jury, they allowed me to go to trial with this disability claim, psychological testing claim. The jury ruled in my favor. The school board had already admitted that they lack authority and they lack a factual basis. They awarded me $300,000. Judge Meredith reversed it. How he could do that, I am baffled. It's just a criminal act on his part. They never reinstated me, but yet they say I was afforded due process of law. Okay? This is State Attorney Jerry here. He conspired and agreed with the officers of the court. It was all about what? Collecting the blood money. This is what you do. You destroy a person. You destroy him psychologically. You destroy him financially. You deprive him of everything. Okay? His reputation, his good name. This is what these fraudulent orders and judgment that they produced did. Okay? But they knew. They knew it like they know the back of their hand that we were entitled to a judgment as a matter of law on all 40 of our claims or more. They knew it. Every judge and every lawyer in this country. They knew it like they knew the back of their hand. And they did it. They did it for the blood money. They set out to destroy us and our livelihood from day one, even to kill us. Reality comes around. It eventually comes around. Okay? You just have to hang in there. Okay? We got to learn how to see through their illusions, their lies. Okay? So this is what it's all about. All it takes, though, for evil, I think Benjamin Disraeli said this, all it takes for evil to prevail is for good men and good women to sit back and do nothing. So you got to what? You got to subscribe and you got to share. You got to share this knowledge. Okay? You got, and I'm going to say this once again. They knew it like they knew the back of their hand that we were entitled to a judgment as a matter of law on all of our claims against Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Harman-Highsmith, the Damron, and the Polk County School Board members, their members, superintendent, and its administrators. Okay? We got to see through the illusions. Okay. That's enough for the day. But in the words of Albert B. Wells, the way you right wrongs is to shine the light of truth upon them. I'm coming back, so hang in there with me.